Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown podcast. I'm Chris Fisher, head of the London Employment Group at Mayor Brown. In this episode of the podcast, I wanted to talk about a recent case from the Employment Appeal Tribunal called Kong and Gulf International Bank. And this is a whistleblowing dismissal case where the dismissal decision is said to have been influenced or manipulated by someone other than the dismissing manager. Someone who is doing what they are doing because the employee has blown the whistle. And the question for unfair dismissal purposes is then whether that other person's motivation can be attributed to the dismissing manager. Now, last year, this issue became prominent in a case that went all the way up to the Supreme Court, which was the case of Royal Mail and Jhuti. That was the case, as many of you will remember, that involved a line manager who took exception to one of his direct reports who blew the whistle on certain alleged activity within Royal Mail. And that was a protected disclosure for whistleblowing purposes. But the line manager decided to engineer a dismissal of the employee by setting up contrived performance concerns, which ultimately led to the employee being put through a performance management process and then being dismissed by a different manager. The dismissing manager knew nothing about the protected disclosure that the employee had raised and certainly didn't know that the employee's line manager had invented the performance allegations. So Royal Mail's argument in that case was that they couldn't be liable for unfair dismissal because the motivation of the dismissing manager was not related to the protected disclosure. It couldn't be because he didn't know about it. But the Supreme Court disagreed. They said that in unusual cases, such as the Royal Mail case, where someone in the chain of management above an employee, here the line manager, decides that an employee should be dismissed because they've raised protected disclosures, but who invents a false reason for that dismissal, then the court has to look through the invented reason. And it can then attribute to the dismissing officer the real reason for the dismissal. So that was the Jhuti case. The facts in the Kong case were slightly different, and they were as follows. Ms. Kong was the head of financial audit for Gulf International Bank. She raised concerns about a legal agreement that had been drafted by the bank in relation to one of its financial products, and she believed that it didn't sufficiently protect the bank and put them at risk of being in breach of its regulatory obligations. The bank's head of legal, Ms. Harding, took issue with those allegations, and that culminated in a meeting at which Ms. Kong questioned Ms. Harding's legal competence, saying that Ms. Harding clearly didn't understand the issue in question. Ms. Harding took this particularly badly. She refused to work with Ms. Kong any further, and she raised a complaint with the bank's head of HR and its CEO. And she said that Ms. Kong had in fact criticised her integrity, not just her legal competence. And she also entered into an exchange of emails with Ms. Kong, which related to the argument, and they were copied to Ms. Kong's line manager, Mr. Mohammed, who was the group chief auditor. Now, the head of HR and the CEO decided that Ms. Kong should be dismissed for the way she had criticised Ms. Harding in their argument, and they prepared a report to go to Mr. Mohammed as Ms. Kong's line manager. Ultimately, Mr. Mohammed, having considered that report, took the decision to dismiss Ms. Kong. And Ms. Kong claimed automatic unfair dismissal on the basis that the reason, she said, for her dismissal was the protected disclosure she had made to Ms. Harding about the defective legal agreement. And she said it was a Royal Mail and Jhuti type situation, in that Ms. Harding had essentially invented the reason for her complaint about Ms. Kong because she had claimed that it was due to an attack on her integrity. Ms. Kong said it wasn't that at all. Ms. Harding had reacted the way she had because Ms. Kong had raised a protected disclosure about the defective legal agreement. And that, Ms. Kong said, was the real reason why Ms. Harding had complained, and so it was the real reason why the dismissal process had been begun by the head of HR and the CEO, and ultimately it was the real reason why she had been dismissed by Mr. Mohammed. But the EAT disagreed. They said it wasn't a case of an invented dismissal reason of which the dismissing officer was unaware, as was the case with Jhuti. Here, they said Mr. Hamid had in fact been fully aware of the disagreement between Ms. Harding and Ms. Kong and the criticisms that Ms. Kong had made. He was also aware of the protected disclosures that Ms. Kong had raised. And that's because all of that was contained in emails that he had seen at the time and in a draft audit report that Ms. Kong had prepared. So it wasn't a case of a dismissal officer being manipulated or misled, as in the Jhuti case. And the EAT said that the reason for Mr. Mohammed's decision to dismiss was not Ms. Kong's protected disclosure, but the way in which Ms. Kong had behaved, specifically the fact that she had questioned the professional competence of Ms. Harding. It seems Ms. Kong had behaved in this way before, and it was causing continued problems within the bank because people were refusing to work with her, as Ms. Harding had done this time. And the view that the bank came to, it seems, was enough was enough and Ms. Kong had to go. And so she did. So although the dismissal was in fact found to be unfair under ordinary principles, it wasn't automatically unfair. And that's because it wasn't motivated by the protected disclosure. And so critically, the cap on compensation for ordinary unfair dismissal remained in place. I think this is an interesting decision for two reasons. First, the comments that were made by the EAT to the effect that the Jhuti principle would only rarely apply. They felt that cases of manipulated decision makers would be an unusual set of circumstances. And that, I think, will be reassuring to employers. Secondly, we often advise employers who are faced with employees who have blown the whistle that they should separate out the whistleblowing process from any other process that might be going on, whether that's a grievance or certainly any form of dismissal process that might be happening at the same time. And the idea for that is to insulate the dismissing officer or the officer hearing a grievance from any knowledge of a protected disclosure having been made, so that it can't be said that they made the decision to dismiss because of the protected disclosure. But what's interesting in the Kong case is that what saved the bank was the fact that the dismissing officer, Mr. Mohammed, was fully aware of the protected disclosures that had been made, and the court could see that the reason for his decision was separate from those disclosures, i.e. it was the way in which Ms. Kong had behaved. So what we can learn from that, I think, is that there will be cases where it will be helpful for a dismissing officer to be aware of a protected disclosure having been made, where the reason for the dismissal is in some way connected to it. The obvious case being one like here, where the reason for the dismissal is the way in which the employee has raised a protected disclosure, or the way in which they have behaved in connection with the raising of a protected disclosure. In those sorts of cases, it will be helpful for the dismissing officer to show that the two things can be separated and that the reason for the dismissal can be said to be something separate from the protected disclosure itself. So that's the case of Kong and Gulf International Bank. And that's the end of the podcast. I hope you found it useful. If you have any comments or questions, as always, please do contact me. And until next time, I hope you all stay well, and I look forward to speaking to you again. Goodbye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.